We have one matter set on the 10:30 docket this morning in the matter of Allison G. Kort. And counsel, you may approach.
Good morning, and may it please the court. The Office of the Disciplinary Administrator appears by Kate Duncan Butler, present and ready for argument.
My name is Britton McClurg, and I represent Allison Kort in this matter. She's also present in the courtroom, and we are ready for argument.
Thank you, counsel. Ms. Butler, you may approach, and as you do, I will announce that Justice Standridge is recused from this case. And as I announced this morning, Chief Justice Martel Duker is not participating in this week's docket. You may proceed, Ms. Butler.
Thank you. Good morning. May it please the court. Once again, I'm Kate Duncan Butler, appearing on behalf of the Office of the Disciplinary Administrator. Justice Rosen, I would request 3 minutes for rebuttal.
Thank you.
Thank you. This case is an original proceeding in attorney discipline involving Allison Kort, who has been licensed to practice law in the state of Kansas since 2015. This matter comes before the court today pursuant to a Rule 223 summary submission agreement. My office often says we use summary submission agreements where the parties are agreed on all matters. In this agreement, the parties have stipulated to the facts, the rule violations, and the applicable aggravating and mitigating factors at play in this case. The parties have also reached a joint recommendation for discipline. That recommendation is that Ms. Kort's license to practice law be suspended for a period of 3 years, but that suspension be stayed for a period of 24 months probation. Further, the parties recommend that Ms. Kort be able to apply for early release from that probation when she completes her 3-year term of probation that was imposed by the Missouri Supreme Court in April of 2024. The probation plan, as well as that recommendation, are included in the agreement located Volume 1, pages 99 to 103 of the record. To summarize the stipulated facts, Ms. Kort was representing clients in the appellate courts in Missouri, and in 5 cases, she repeatedly missed briefing deadlines. In some of those cases, she would ask for additional time when that time had elapsed. In others, the court granted her additional time on its own motion. But regardless, in 4 of those 5 cases, Ms. Kort filed briefs either late or that did not comply with the briefing rules in Missouri and that were stricken, leading to the appeals being dismissed. There was a 5th case in which ultimately the appeal was heard on its merit. As the appeals were dismissed in some of the cases, Ms. Kort filed motions asking the court to reconsider the dismissal or reinstate the appeal. In those, she took responsibility for missing the deadlines, said that she was suffering from overwork, failing to manage her caseload, and failing to manage her time, her work schedule, and her obligations. This all happened in late 2022 and early 2023. And in or around March 2023, the Missouri Office of Chief Disciplinary Counsel, or OCDC, opened an investigation into Ms. Kort's conduct in these cases. Ms. Kort did not initially participate in OCDC's investigation. And on OCDC's motion, the Missouri Supreme Court issued an interim suspension of Ms. Kort's license to practice law in June of 2023. After that, Ms. Kort re-engaged with the process. She self-reported her interim suspension to our office in Kansas and ultimately entered a stipulation and agreed recommendation with Missouri OCDC. In that matter, the parties jointly recommended that Ms. Kort be indefinitely suspended from the practice of law with leave to seek reinstatement after 1 year, but that period of suspension would be stayed for a 3-year term of probation. The Missouri Supreme Court adopted the recommendations and the stipulations on April 2nd of 2024. That order is Exhibit 6, found in Volume 2 of the record. So this is a reciprocal discipline case. It came out of Missouri. It involves conduct that occurred in the Missouri courts. In the Missouri stipulation, Ms. Kort stipulated to certain violations of the Missouri rules. And in our agreement, she stipulates to the Kansas equivalents of those rules. Those are KRPC 1.1, competence, 1.3, diligence, 3.4 subsection C, knowingly disobeying the obligations of a tribunal, and 8.1 subsection B, failure to cooperate in a disciplinary proceeding. Clear and convincing evidence in the stipulations and in the record, which includes many of the documents from the Missouri proceeding, show that Ms. Kort violated these rules by failing to meet deadlines, failing to submit briefs that complied with Missouri's court rules, failure to respond to the court's order deadlines, and failure to cooperate in Missouri proceeding. As I said earlier, our recommendation, the party's joint recommendation here is a 3-year suspension from the practice of law, stayed for a 2-year period of probation. It is our position that the probation plan complies with Rule 227, which is our probation rule. It is workable, substantial, and detailed. It provides adequate safeguards to address the misconduct, and it protects the public, and essentially ensures that Ms. Kort continues getting treatment for her mental health conditions and continues to build case management, law practice management skills, and adequately manage her caseload so that these sorts of things don't happen again. She has excuse me.
This, when I look through this is what puzzled me. So I understand the practice supervision part of this. Where's the part that addresses the mental stress and health issues that are identified here?
I believe in the probation plan, there is a provision talking about she is to continue with her mental health treatment. If you give me a moment, I will look for it. Yeah, so it is paragraph 6 of the probation plan that she is continuing to participate in counseling and therapy following all treatment recommendations, and that upon request, Ms. Kort will provide our office with reports from her treating professionals outlining her diagnosis, treatment plan, condition status, and all of that. So that is paragraph 6.
That's something you guys routinely do when you've got a provision like that, is you'll request an update periodically.
Precisely. And we often, in cases where mental health or physical health are part of the reasons for misconduct, it is not uncommon for us to include that element within the probation plan to ensure that the attorney is continuing to get the treatment and support they need for those.
One other question. So KLAP's involved with this.
Mhm.
Do you rely on KLAP to update you about that, or do you specifically go in to get these periodic updates directly from the respondent?
The respondent has a reporting requirement and I believe in this case, it's a quarterly reporting requirement to ensure us that they are complying with all elements of probation. And so we often rely on those unless there is reason for us to ask for further information. So it might be the update was silent or not robust enough on one of the issues. So, hey, will you provide additional documentation? I don't know off the top of my head that we have a release with KLAP. I think Ms. Kort could certainly answer that question. But I am not the attorney in our office who monitors probation, and so I do not know all of the steps she takes in every case. Do you have further questions on that? Perfect. As I was saying regarding probation, Ms. Kort has been supervised in Missouri on probation since April of 2024, and by all accounts, that is going well. When we are imposing attorney discipline, this court looks at the ABA standards. And here, the standards that most directly apply are suspension standards, which is why there's the request for the underlying term of suspension were Ms. Kort not to be successful on probation. The most appropriate standard is the suspension standard for a lack of diligence, which is standard 4.42. Missouri also looked to that standard. It's discussed in the stipulation, although I noticed the other day they cite to standard 4.41, but then quote 4.42. I believe that is a typographical error. Regardless, 4.42 is stated in the alternative and says that suspension is appropriate when a lawyer knowingly fails to perform services and causes injury or potential injury, or when a client or an attorney engages in a pattern of neglect that causes injury or potential injury to a client. Similarly, the standard for disobeying the orders or rules of a tribunal, the suspension standard, standard 6.22, is appropriate to look to in this case. That standard states that suspension is appropriate when an attorney knows they are violating a court order or rule or causes injury or potential injury to a client. Here, Ms. Kort was engaging with the courts even as she was missing the deadlines, which shows a level of knowledge, as well as the injury being fairly severe. 4 of her 5 clients had their appeals dismissed due to her misconduct. I will also touch very briefly on the aggravating and mitigating factors that apply in this case. The aggravating factors mostly concern the extent of the misconduct. She engaged in a pattern of misconduct that impacted several clients and committed multiple offenses. She also has substantial experience in the practice of law. She was admitted in Kansas in 2015, but has held law licenses in other states dating back as far as the year 2000. However, there are significant mitigating factors which are sort of touched on in the mental health part of the summary submission agreement. Ms. Kort has no other discipline apart from anything stemming from this action. She cooperated fully in the Kansas case. There was no evidence of dishonesty or a selfish motive. She had personal problems, including her mental health diagnosis, leaving her feeling overwhelmed. She made a good faith effort to make restitution to her clients. She's actively involved in the legal community, and she has shown remorse in these proceedings. And so for all of those reasons, it is the recommendation that although there be a underlying suspension, should she not be successful on probation, that she be placed on probation for a period of 2 years and allowed to apply for early release when she completes probation successfully in Missouri, which would be, assuming her Missouri probation is not extended for any reason, in approximately April of 2027. If the court has no further questions, I would waive the rest of my time.
Any questions, colleagues? Thank you, Ms. Butler.
Thank you very much.
May it please the court. We would like to offer Ms. Kort 5 minutes to address the justices herself. And I'm going to try to keep this brief so I'm not repeating everything that Ms. Butler indicated to the court. But the purpose of discipline is not to punish. It is to ensure the integrity of the profession. It's to protect the public, and it's to deter similar conduct in the community. And the probation plan that we have in place and are offering to the court does those 3 things. This is a case of reciprocal discipline. Ms. Kort was suspended by the Missouri Supreme Court on an interim basis because of some delayed filings in the Missouri Court of Appeals. In this matter, suspension is generally the appropriate discipline because there was harm to clients. Some of her cases were dismissed. But in this case, Ms. Kort has always admitted that she made mistakes. She has always recognized that errors occurred. She self-reported her conduct to all of the relevant bars that she is a member of. She is incredibly remorseful, as I think you will see when she makes her presentation to this court. In every case, she has returned client funds for every affected client and took great personal pains to do so. And as Ms. Butler indicated, she has no prior discipline outside of these issues. These issues did occur over a 2 to 3 month period where there was some substantial mental health issues going on in Ms. Kort's life. And due to those circumstances, she proactively sought mental health treatment. She became engaged with KLAP very early in this process. She also increased the frequency of her counseling sessions. She also had some medicine changes with her psychiatrist. She has maintained those relationships throughout this process going forward. All of her mental health treating professionals agree that her condition is well managed and she is able to practice law. In doing so, we have agreed with the Office of Disciplinary Administrator to continue those practices as outlined in the probation plan. Ms. Kort is to continue her treatment as outlined. She's going to continue working with KLAP, and I understand Justice Biles had a question about whether there was a release for KLAP records. To my knowledge, there has not been a release. It's not been asked by the Office of Disciplinary Administrator. However, Ms. Kort has no issue with signing that, and she's certainly willing.
I'm less concerned with that than I am just trying to figure out how much reliance the Disciplinary Administrator's office is putting on self-reporting from your side of the ledger as opposed to actively asking. I mean, you know, you can actively ask, then you get a representation from the respondent. I'm okay with all that.
Yeah.
Well, facts will determine whether the representations were correct. It's just the reliant, who's relying on whom in this process to make sure that she's successful.
Right. And I understand that concern. I think that is a better question for the Office of Disciplinary Administrator to answer as to what steps they intend to take. But Ms. Kort is willing to sign whatever releases the Office of Disciplinary Counsel or Office of Disciplinary Administrator requests of her, and she is certainly willing to provide any records or correspondence from her treating professionals to reassure the Office of Disciplinary Administrator that she is capable of practicing law. Also, to that end, she has been working with Amy Elliott, an attorney here in Kansas, to work on case management, to make sure that she is calendaring deadlines appropriately, to manage her caseload so that she's not taking on too many cases, and is able to meet all of her deadlines. And since she has been reinstated in Missouri, she has not missed any deadlines since that time. And I believe that is all I have for your honors, unless you have any questions. Otherwise, I will turn it over to Ms. Kort.
Quick question. Sorry,
Yes.
go ahead. Go ahead.
I was just going to ask if everything goes according to plan, after the 24 months of probation and reinstatement in Missouri, what happens to the remaining term of the suspension? And is there a reinstatement hearing? I guess I didn't see. What is your understanding?
Our understanding was once probation is completed, that would terminate the process and there would be no need to apply for reinstatement in Kansas. And
Okay.
that is the same as in Missouri.
And my question relates to the Missouri plan as well. So I understood the Office of Disciplinary Administrator's position is that the plan you have here, the probation plan, is workable. Just from your perspective, is it? I mean, I realize you're also working a plan that came from the Missouri office. So
Correct.
are those two things together workable?
Yes, and honestly, the Kansas plan that we have adopted is largely based in part on the Missouri plan. So there are some additional components to the Missouri plan. I honestly can't tell you exactly what they are off the top of my head, but they all do involve a quarterly reporting requirement. And Ms. Kort has executed medical authorizations and those kinds of things. So the Office of Chief Disciplinary Office of Chief Disciplinary Counsel in Missouri is capable of obtaining those records. I don't believe they have done so at this point, but that has been the other thing. Oh, the other thing in the Missouri plan that is different is there are some additional trust fund monitoring issues, just to ensure client funds are kept in trust as they are supposed to. And so Ms. Kort has also signed an authorization for bank records to be produced, and if requested, she would be willing to do so. That's the other major difference, I believe.
Thank you.
Thank you. All right, I'm going to turn it over to Ms. Kort.
Thank you.
Thank you.
May it please the court. It's gonna be hard, okay? I'll be okay. I appreciate the opportunity to speak before you and for you to listen to me today. I want to just start off I want to describe some of the circumstances that were surrounding the actions that led to my discipline in Missouri. But first, I want to acknowledge my responsibility as an attorney and an officer of the court to represent my clients zealously, to not miss deadlines, and that my actions had consequences that really affected my clients' cases. One thing I did want to just clarify is that these appeals that happened in Missouri, yes, I understand that there was a pattern of misconduct. It all happened very, very fast at the end of 2022, mostly between that time between the Christmas and New Year's, that couple of weeks time span. And the cases were child custody appeals that were on an expedited appellate briefing basis. And my biggest mistake was in taking on too much work and believing that I could make it right. I was always very aware of I feel like we live and die by the deadlines. I feel like I was always very aware of my deadlines and my responsibilities in filing these custody appeals. And I think that I had some arrogance in believing that I could make it happen or change the ruler. I'm not even sure what, other than I was spinning my wheels, and I became very overwhelmed. I became very overwhelmed with trying to get these briefs done on time, and I took on too many expedited appeals at the same time. And I didn't ask for help when I needed it. And I thought I could fix it, and I was unable to do so in time to avoid harm to my clients. I think I've been an attorney since 1999. I took the bar in New York. And I love appeals. It's all I ever want to do. It's all I've ever wanted to teach, to be part of. I clerked for a federal judge in New York when I got out of law school, and then I was at a law firm for a few years, but I really spent most of my time doing the death penalty appeals pro bono. And then I went into the academic profession side, and I became a legal writing professor, which I truly loved. And then I went out on my own and did my own solo practice. So even though I've been an attorney now, it will be 26 years. I was ill-equipped to manage a solo practice 19 years out of school, thinking that I could just manage it. So that was a very difficult. Plus, this was at the end of 2022. After there had been I had received several appeals, multiple appeals in Missouri from child custody decisions that occurred during COVID. So they were over video. And I think there was just an influx. It was kind of a perfect storm. As far as my mental health goes, I was diagnosed with anxiety and depression while I was in law school at the University of Texas. And I've consistently been in psychological treatment as well as medication management. But I think that when this overwhelm was going on, I wasn't sleeping. I'm a solo parent of one child, and she was in 6th grade during COVID. And so I was trying to manage learning at home and what was going on with all that. And I found that the only time that I really had to myself was in the middle of the night. So I wasn't sleeping. So I was neglecting my own physical and mental health, which was, and especially the not sleeping and working all the time, made my brain somewhat discombobulated and unable to really perceive, I think, the reality of what was going on, that I needed to ask for help and do what I needed to do to take care of my clients. Sorry, I'm just trying to. I think since that time period, I feel like this has been a lesson in humility and in humanity. When I received when I was suspended on an interim basis in Missouri, part of what I had been so busy, and I had a PO box and I had been working at home. I just had left my office since 2020, since COVID. And I was working at home by myself, which is also not the right decision for me. And since then I now have an office in a building, and it has made just a world of difference connecting with other people. And even if I'm not practicing with them together, I think I was spending too much time alone and isolated writing briefs and trying to perfect them. But when the interim suspension order came out, I had a PO box and not a physical address. And I hadn't gone to my PO box frequently enough that I didn't receive the complaint from I'm responsible for it, but I did not receive the mailed complaint from the Missouri OCDC, which was the reason that I didn't participate in the process right away. So I did receive the notice of interim suspension in June of 2023, where I immediately called my attorneys, who have been so instrumental in assisting me in this process. I was unable to practice law in Missouri for 10 months while I was trying to work through the disciplinary process there, I did call, I called the Kansas OTA immediately as soon as it happened, because I was concerned about practicing law while my license was on interim suspension in Missouri. And the Kansas OTA has been, I feel like, very generous and willing to work with me. I entered into a voluntary agreement with KLAP. Primrose is here to support me. She called me last week to ask, and I feel just incredibly grateful for that support. My mentor, my attorney, my probation attorney mentor is Amy Elliott, who I'm sure you all know is very involved and a member of the KLAP board. She's a friend of mine from way back, and she actually had said, "Hey, Allison, I think you should get involved with volunteering with KLAP to work with other people." And I said yes, and then I wound up getting my license in Missouri and getting a whole bunch of appeals. But to speak to that point, since my interim suspension order, and then since it was lifted, I don't want to say reinstated because I was never uninstated, just sort of interim. I actually have had several opportunities to assist other attorneys who have gone through something similar or are facing an interim suspension order. They've found me, and I feel like it's a gift to be able, if I could give back in any way with what I've been through, then I want to be able to do that, because I think that I just can't imagine that anybody takes the bar intending to harm other people with because of their own stuff going on. So since that time period, I'm in biweekly therapy. I go for medication management. I had a business coach. I have a physical office, which is a lifesaver. I'm no longer my child is no longer in school at home. She's actually a senior in high school now. So that's good. I'm working with KLAP. I've also gone with the KLAP, the resiliency group, which is just incredible for me to be able to connect with other folks and realize I don't have to do it alone, and I don't have to pretend that I can do it perfectly. I was a law professor for 10 years, and I think that I just I feel like I feel badly that I'm sorry. I feel bad that, my students all over the country. I'm human, and I made mistakes, and I regret them. And I'm very committed to making sure that this never happens again, because I really still love doing this work, and I just want to keep doing it, and I'm achieving good results for clients. Since my interim suspension, I'm sorry, I'm out of time. I'll just finish up really quick. Since my interim suspension, I've slowly been able to start building my practice. I will not take on more than one child custody or termination of parental rights appeal. They're not only are the deadlines expedited and jurisdictional, but the cases are they're very heavy, and I think that it's a good idea to not take on too much of that. I welcome any questions, but I appreciate the opportunity to be here.
I want to make sure I understand that your present circumstance with practicing law is in an office with other attorneys.
I work, yes, thank you, Justice Miles. It's not, I work in a co-working space. So I have my own office there are other it's a whole bunch of solo people, business people in the same building, but there's a lot of connection together with how the co-working office works. I do know other attorneys there. We talk to each other. We actually meet, we go to lunch. And it's a very open communication sort of situation. It actually was surprising. I was just looking for a place to go, but it's actually sort of a really nice, vibrant atmosphere.
I'm just trying to clarify. Typically, I mean, back in the day, lawyers would share office space together. I'm understanding you to say this is something more than that, that there are various professions in sharing the office space. Some are lawyers.
That's correct.
Okay.
Yes.
Colleagues, any other questions?
Okay.
Thank you, Ms. Kort.
Thank you very much.
Appreciate your presentation. Ms. Butler.
Just to briefly clarify two questions that came up. I don't remember if it was Justice Wall or Justice Biles asked what happens to the underlying suspension if whether Ms. Kort were to complete all 2 years in Kansas or early release. To opposing counsel's point, I do think once she is released from probation, all of the discipline is essentially over. And so if there were the suspension term essentially is unserved because she has completed probation and there was no need for the suspension to be served. And then Justice Walsh, you asked about the workability with the Missouri plan. They are very, very similar plans. The reporting dates are the same. It is the same probation monitor, so it is not duplicative in any way. In order for Ms. Kort to be able to successfully do both plans without it feeling like a whole second job that she must undertake in order to be successful, the Missouri plan does have the additional trust accounting requirement. We don't have that requirement because trust accounting was not an issue in this case, so our office did not ask for it. And Missouri recommended some continuing legal education that she will benefit from regardless of what state asks her to complete it. So we did not add any continuing legal education requirements either.
And in New York, is there a suspension, but there's not another plan? Or
That is my current understanding of the situation with the state of New York, yes.
thank you.
Yeah.
If just, New York does not have, the New York disciplinary plan, they don't have a stage suspension with probation instead, so New York suspended my license for a year, that term has passed. But, I don't have a reinstatement hearing, but I do need to just get my application in.
Thank you.
And if there are no further questions from the court, I would waive the rest of the rebuttal.
Any questions? Thank you. That concludes this morning docket.